In most cases, borrowers file for bankruptcy because of the ability to discharge their debt in Chapter 7 or Chapter 13 bankruptcy. A bankruptcy discharge is a permanent court order releasing the borrower from responsibility of having to pay the debt, and it prohibits the creditor from taking any collection action against the borrower. However, in some cases, a borrower may want to reaffirm a debt in bankruptcy rather than discharge it. A borrower will usually reaffirm a debt when the debt has collateral that the borrower wants to keep, such as a car or valuable jewelry. When a debt is reaffirmed, the borrower voluntarily agrees to pay the creditor all or a portion of the money owed. If a debt is reaffirmed and the borrower fails to pay the debt, that creditor can then seek repossession and other legal actions to collect the debt. Reaffirmation agreements are completely voluntary, meaning a borrower in bankruptcy can never be compelled to reaffirm a debt. In addition, all reaffirmation agreements must be approved by the bankruptcy court before they can become effective. A court will only approve a reaffirmation agreement if it is in the best interest of the borrower, the agreement is entered into voluntarily, the borrower has the ability to repay the debt, and the creditor gives something of value in return for the borrower signing the reaffirmation agreement. Reaffirmation agreements can be a good tool for borrowers, but only if used in appropriate situations. If the property you want to keep qualifies for a bankruptcy exemption, in some cases it may not be a good idea to reaffirm that debt. If the property is exempt, the borrower will be allowed to keep the asset without having to reaffirm the debt. Which type of property and the amount that is eligible for an exemption will be determined by both federal and Florida bankruptcy law. If you have questions about the type of property and amount that can be exempt in bankruptcy, contact us to speak with an attorney at our firm. Most questions regarding exemptions can be answered over the phone. For more in-depth discussions, we offer free in-person consultations for borrowers considering filing for bankruptcy. Additionally, there is valuable information on reaffirmation agreements published by the Florida Bar Association. If you are having a difficult time meeting your financial obligations, Florida law advisors may be able to help. Our bankruptcy attorneys in the Tampa Bay area have years of experience helping people just like you solve their financial problems. We understand these are very difficult times for you and are here to help. We have many options available that can help you successfully manage your debt and regain your financial health. In some cases, filing for bankruptcy can be a good solution. However, it is often not the only solution available. The right course of action will depend on the unique circumstances of your case. For more information, give us a call to schedule a consultation with a bankruptcy attorney at our firm. During the consultation, an experienced attorney at our firm can review the facts of your case and help you choose a course of action that is best for your specific situation.